welcome to the Wellness and Legacy Networking Group, where we are committed to connecting death care professionals. Mostly everyone on the call as of now is very familiar with who we are and what we do, but our goal and mission is to align the death care industry and us as professionals to sharpen our swords together. This is our amazing group that locally gets together in Ponte Vedra, Florida, in Nocatee. Our next luncheon is March 6th. So if you haven't already signed up, there is a link in the chat for you to go ahead and get together with us in person. Our mission and vision is to create a seamless connection between the wellness industry, which serves people prior to death, and the legacy, which supports individuals and families post-death. What our team has realized is that these industries often serve at the same time and almost simultaneously. So this collaboration is an effort to learn more about the industry and understand how we can cross-collaborate with each other. Today, yours truly, Carolyn Castillo and Holly Schutthauer, we are with Probate Property Angels, and we will be your hosts for this event. We help families that inherit property either through trust or probate and handle the affairs of the real estate. We are going to be diving in. How did this all get started? Well, we understood that we needed to create a mastermind of industry professionals. These conversations are happening from professional to professional so that we can understand exactly what's going on to the right and the left of our customers. A lot of times as professionals, we only focus on our specific niche, on what we specifically do. But what we understood is that by leveraging the knowledge of the professionals to the right and the left will basically rise us all together to be more in the know and know how to refer and cross collaborate so that we can better help our communities and professionals. So we are jumping in. Last week, we had the amazing pleasure of getting with Chris Morrison from the Legacy Retirement Group, which spoke to us about financial planning, how to assist professionals in understanding what are the resources for financial planning and how it affects you. Today, we're going to be working with estate law attorney Chris Leddy with Heekin Law. And next week, we are going to be speaking with Elizabeth Brandenburg, hopefully I said that right, from Hardage Giddens regarding funeral planning and what that looks like. So between all of this, we are going to be some very sharp tools in the shed. I'll tell you that, guys. So with all that being said, let's go ahead and bring up our featured speaker today, Chris Leddy. Thank you so much for being here.
Yeah, thanks for having me.
Amazing. So today you are going to bring us home in regards to understanding what is the value of estate law planning. Probably a good question is to jump in is why so many people put it off, right? Educating us as professionals, I think that we're going to figure out how to start having these conversations as professionals and, ultimately getting everybody with an estate plan so they don't have to go through probate. Their family doesn't have to, suffer through post-death and everything that comes with that. So thank you so much for giving us your time today and diving into this. So we could just go ahead and jump off. What is it in your opinion versus people getting a will? You commonly hear that, well, mom had a will, we went and got a will, we're good, we got a will, we got it all on paper. What are the advantages of setting up a trust, really doing estate planning versus just having a will?
Yeah. Well, and that's, the answer to your question is really straightforward. It has to do with cost in a lot of cases. Some folks think that trusts are these really, really expensive instruments, and they don't have to be. But it certainly is something that is more expensive than a will. But when you're looking at it from a perspective of how much a probate estate will cost if your family has to go through probate, how much it's going to cost them and your loved ones, it can really eat away at the inheritance that you would otherwise leave your heirs. A good rule of thumb, depending on the type of asset, specifically if there's real estate, is that a probate estate could eat away, just from the cost of administration with attorney's fees, personal representative, executor commissions, realtor fees, storage, things like that. It could eat away at about 10% of a probate estate, depending on the value.
I
And so if you do some pre-planning with a revocable living trust or an irrevocable trust, there's all kinds of different trusts, and we could go into that as well. But if you do some pre-planning, you can really mitigate some of that cost and heartache that your family would have to go through. And I hear people all the time say, "I've got a will, we're good." Well, there's a difference between what is referred to as an intestate estate, where somebody passes away without a will, and a testate estate. Intestate means you die without a will. Testate means you die with a will. And if you go through the testate process, you're still going through the same process. The only difference and distinction, if you die with a will, is that you are telling the court who is going to be administering the estate, who is going to be receiving an inheritance from the estate. That's really the only difference and distinction than dying without a will. And so,
Well, let's unpack that because you just like threw like a bunch of good stuff on us. So let's like take that down a notch, right? So
sure.
you had first, let's talk about the cost, right? Because I think that that is really important. What you mentioned is that why don't people do the trust versus doing the will? Well, you could go online, you can create a will, there's all these like, easy ways to create a will, right? So like you said, it's not a lot of financial investment, it's not a lot of financial commitment. But what people don't really, I think that because death, even though we were at a meeting this morning and the guy said you don't know how long your string is. You don't know how long you have, right? Every single person, they kind of don't really take in what would actually happen after they passed away. Like how you're talking about, oh, they're gonna say, when they pass away, their family and all that there's like a disconnect between the reality of like that happening, that they're not like, it's not like a value add for some people because they think they've got plenty of time, it's down the road, they're young. um what is, and I know every estate is different, every trust is different, but what is to have a good will written and to have a trust, what would be the cost, just as a roundabout, just so that we can have a context?
Um, well, when it comes to will-centered estate planning for a couple, ballpark costs, somewhere in the high three figures to, certainly, I mean, depending on the extent of planning, under $2,000 with a last will and testament centered estate plan.
Mm-hmm.
When you're looking at trust, you're right about there at 2,500, depending on complexity, can be in the ballpark of 3 to 4. For the super complex estates, when we're doing some asset protection, it can be higher. It can be in the 5, 6s, and 7s.
So it's
But
not like a huge, humongous disparity between the two.
No, no, and that's the thing that I think, you can go online and get a will done for, I don't know, you go to willsandtrust.com, and I don't know what they charge, maybe 75, $150. You get a will or a trust. And quite frankly, that's where we see a lot of mistakes made, because the client who is preparing that, or the decedent who's preparing that, they don't understand what they're doing. They don't understand the verbiage, what a personal representative is, what a guardian is, what, some of those things that are very important. And then on the back end too, are they getting it signed properly? Right. So I had a client come to me who hired us last week, who went and did their own will at willsandtrust.com, and actually had his mother sign as a witness to the will. Um, if in a scenario where his wife and children pass away, his mother would be a beneficiary under the will, specifically the way it was written. And so, because of her signature on that, she'd be what we call an interested beneficiary, and she would not be able to inherit under the terms of that will for it to be deemed valid. So, these are just basic things that people, and I see it all the time where people make a mistake just because they don't understand what's going on or they don't understand the testamentary formalities of the signing process, which can get your loved ones in hot water.
So let me ask you this. Is it true to say that a will it does express your wishes, right? It could be you know, wrote wrong, right? Where it didn't really, like you said, someone went on willsandtrust.com and just kind of said, "Oh, I have a will," but doesn't really understand how post-death plays out and what the legal ramifications are of post-death, right?
Okay.
So
Yep.
you have a will, and then for us, right, we're working probate a lot. People have wills, but these wills are then submitted to the judge. And then the judge ultimately has a ruling over, just because you have it in a will, doesn't mean that that's exactly how everything's going to be played out. Is that right or wrong?
For the most part, what provisions you put in your will are going to be a complete expression of how it plays out. The problem and the distinction, I think, is that a lot of folks don't understand the process. So when they do the do-it-yourself wills, they might say one thing on paper, but they don't understand how that practically relates with the probate process. They don't understand, for example, that if direct the sale of your real estate and it's your primary real estate, if you direct the sale of that and the proceeds be distributed to your heirs, that can actually cause a big problem for your heirs because then your heirs are going to lose the homestead creditor protections after you're gone. And so those are just
Mm,
things that,
little nuances that
an attorney would understand, but if you're doing it yourself, you're not going to understand it and you're not going to be able to, fully grasp, what the ramifications are for your beneficiaries.
I have one more selfish question on this subject. Is there any foolproof on a will getting contested by another beneficiary versus a trust being contested? Is there any where you'll have more protection in the trust versus having the will?
I put no contest provisions in wills and trusts all the time. But that is more meant to be dissuasive of litigation, to dissuade beneficiaries from fighting. Um, the binding nature of that really depends on whether or not a good faith action has been brought, and whether or not the beneficiary, can prove that the decedent or the trust maker, the grantor of the trust, had capacity, was under no undue influence, was under no duress. Those are factors in determining whether or not the trust or the will are valid. I'll say this: when it comes to trust planning, trusts are more isolated from disputes regarding its validity because trusts are privately administered. And so when you have a valid trust on its face, it is very, very hard to not only challenge the validity of that, but then also to bring it in court. And so that's one of the reasons I prefer trust planning. I think, I'm an attorney and I don't like going to court. I have a hearing. I had a hearing last week regarding trustee compensation. I have a trial regarding some related issues on Thursday. I'm not in the courtroom very often. I would say probably, maybe once every 3 months or so. I'm an attorney who doesn't like going to court, and I don't like my clients landing in court because I think that there's a lot that can go wrong when, um, the answer to your question is kind of in someone else's hands.
Mhm.
If you've got a trust that's very clear and very express on how things are to be administered, you've taken it out of the court's hands. You've taken it out of largely your family's hands, and you've put it in the hands of someone you trust as trustee to do the right thing. So
Yeah. It's really, really good. I think this kind of leads us right into really why trusts are preferred is when we come down to our children and minors,
Yeah.
right? Because could you put your wishes affirmatively in a will that would say, I want, so and so to take guardianship of my child in a will, or would you have to have a trust or a guardianship to put
You
that in?
know, yeah, the guardianship provisions are going to be actually expressed, commonly they're expressly stated in the will. And so when someone passes away and they are, um, they're in a spot where they've got a trust in place or they've got beneficiary designations, but they've got these minor children. There is going to be a probate process there to probate the will in order to have that guardianship hearing concerning the minors if both mom and dad are deceased. Um, but as far as like if that's the only thing we're probating is just trying to determine custody of the children, then that's a horrific thing for the family to go through, but it's a good thing to probate. And if we can keep everything else specifically related to the financials out of the court system, I think it's probably in the minor's best interest and in the family's best interest.
Mm-hmm,
Um,
mm-hmm.
in the state of Florida, a minor can inherit up to $15,000 without any kind of court-appointed guardian. Well, we're not typically looking at, $15,000 or less when it comes to minor inheritance. Um,
Right.
and so there's different ways and different strategies to ensure that your minor child inherits from the estate. And it's, a common thing that people do. It just is a basic thing you should be doing is what we call a testamentary trust. That's a trust that's established through a will. And that trust does not exist until you die, right? And that trust can be for the benefit of a minor child. That's one of the most basic levels of planning. The downside to the testamentary trust, in my opinion, is it's publicly administered. And so to that end, your minors are going through the court system until that trust is fully administered. Whereas, with a revocable living trust, it's privately administered, and you can have sub-trusts for minor children spelled out there.
Okay. So tell us a little, what are some of the strategies that you recommend? You have a client, there's minor children involved. What are the basic, you know, precautions that you're putting out there to say, let's make sure that you don't end up in court, that the kids don't have to go to court. We get your, who's going to take guardianship of them on board with you. Um, what does that look like?
Yeah.
Seems like
So
such a sensitive subject too,
it is. And,
it's
and I mean, to be clear, the documents that I prepare for clients, I don't take this lightly. They're signing some of the most important documents of their entire life, right? And so, there's different stages of life that people are in when they come to me for signing a document. They're either, they could be in the asset acquisition stage of life where they've got some things like they've got a house, or maybe they don't even have a house, but they've got kids. And so we need to do some basic planning with a will-centered estate plan. Or I have clients who are kind of on the tail end of life headed towards retirement or in retirement, where they're more of in an asset preservation stage of life or legacy planning, really trying to
yeah, we
think.
got all that education last week from
Yeah,
Chris.
that's
So
right.
that was
Yep, yep. So it
good.
kind of piggybacks off of what
Yeah.
Chris said last week in a way. But I'll take myself for an example. I've got a wife, 4 kids. My oldest is 7, my youngest is 1. We've got a house in Rivertown. We've got I other than that, we've got a couple of cars and a holding company with business, LLC business interests. And for myself, what I'm not a do as I say, not as I do kind of lawyer. For myself, I've got a revocable living trust, a family trust set up that provides for the disposition of our estate in such a way that if something happens to me, everything goes to my wife and vice versa. Something happens to both of us. Then it'll be split 4 ways between our 4 children, where they get a third at age 30, 2/3 at 35, the rest at age 40, and kind of protect them from themselves, protect them from a failed marriage, protect them from their creditors if they have some when they're older. And right now, that's used in conjunction with the pour over will, that has guardianship provisions that state where the kids go if something happens to mom and dad. And so that's, I mean, there's some other documents in the estate plan, financial power of attorney, healthcare power of attorney, those things. But that's,
Sorry to interrupt, Chris. What about in the event that in the, unforsaken that you were to pass while they're still underage, while they're
yeah.
still minors? How have you, I don't know if you share you specifically, but people in that, don't you have to select someone to?
Yes. Yes, and we've changed it 4 times. And my oldest is 7. So
Oh my gosh. Thank you for sharing that because I think that that's a really like human thing. Like, relationships change over the years, and it's like who maybe I would trust with my children today would probably not be who I would have picked 10 years ago.
yeah.
Oh, and how do you even choose a person? And then like, should there be a conversation? Because in the event that that does happen and you talk about that they would receive their inheritance at 30 or 35, but if that were to happen at a younger age, then isn't that financial inheritance going towards their upbringing and taking care of them?
Yes and no. So there are provisions in our trust that allows the trustee who's appointed access to funds to make distributions in their discretion for the children, for health, education, maintenance, and support, the HEMS, right? And those 4 things can be very broad. If they need money for a car, if they need to pay for college, if they need to pay for, going to art school, those are things, if they've got some medical debts, those are things that can be, the funds that we would leave them can be used for that, regardless of their age. Um, and so to that, if they need braces, if they, have a broken arm, those are things that the trust can pay for that. They don't have to be 30 years old for that to happen. Now I recommend to my clients, now I know other attorneys who say, hey, revisit your estate plan every 3 to 5 years. I tell my clients, quite frankly, and I don't know if this is why I'm very busy in January or in February because of this, but I tell my clients to look at it every year. Um, and the reason I do that is because I want my clients to take a proactive approach to their estate planning.
Mhm.
I want my clients to understand that the relationships that you have can change over time. Just because Aunt Susie's a good fit to be trustee now, she might be going through something in 6 months where she's not a good fit anymore.
Mhm.
And quite frankly, we had that happen with guardianship provisions, right? We had my wife's cousin named as the primary guardian. They were the godparents of our first 2 children, and then they got a divorce, and so they're no longer suitable to.
Mhm.
We wouldn't want to put that on one of them.
Mhm.
So they're not a suitable couple anymore for the lifestyle that we want with our kids, to the upbringing that we'd want. Um, Her cousin's great, love her to death, but it would be too much for her. And so we have thought through that, and then it was my sister for a period of time, and then now, I had a relationship with her that changed over time, and we just had different lifestyle things that we saw. We didn't see eye to eye on some things, and so now it's Macy's, my wife's dad is primary guardian, and then you know her mom is secondary, but that guardian would work hand in hand with the trustee. We structured it in a way where the guardian, the person with custody and control, is different from the person managing the finances. And I think that's an important estate planning strategy for folks to implement, because you don't want you I mean, it's okay to have them as the same person, but you generally want somebody who's managing the money removed from the situation so they can make a more mechanical, take a more mechanical approach to how they're administering the trust. And so, I recommend that. And quite frankly, sometimes with clients, they just don't have it. They don't have multiple folks who, where that would make sense, and that's okay. But it's just a word of caution that I provide. So.
So I want to commend you and thank you for being so transparent with us. And I think it just like really just creates a very real environment, right? You're a real family with real kids, with real changes, with real family situations. Like you are exactly what I go through, what everyone goes through on this call. So thank you for sharing in that way. So life insurance, is that something that because I think about this like if I were to name, and did you have a conversation with all these different family members at all these different times? Like, how does that even go? Like, how do you even start?
Yeah, it's hard. It's hard. And we're going through a process of updating too because of my daughter who was born about a year ago. We want to make sure I've got afterborn or adopted language in the document, but we want
Gotta
to
get her in there.
we want to get her in there. And so and we're talking through the process of updating the guardianships right now where we would name my cousin who's down in Jupiter. And we've had the conversations with them. They're totally up for it. But it's such a
Can
hard
you just give us like just how you would have that conversation? Just a quick like, hey, cousin from Jupiter, yeah, I wanted to go over something with you.
Yeah, I mean, personally, I think it's best to have that conversation in person. I don't think a phone call, it's okay to do a phone call, but certainly not a text message or an email. And the way we did
Hey,
it,
by the way, I just signed you up and my kids will show up at your doorstep on.
yeah. Well, the way we did it is we asked them to be our godparents for our youngest daughter. And we've had three different godparents. They're the third set of godparents we've had for
I'd
our
say
four children.
godparents really serious. Like my godparents are just like my besties. Just like,
Yeah.
we take pictures and stuff, but that's amazing. So you really
Yeah.
like your godparents are actually godparents. Like they are.
Yeah.
Okay.
Yeah, I mean, really, we're Catholic. We go to San Juan del Rio, and we take it seriously. And so, it started with asking them to be the godparents, and then it turned into saying, "Hey, listen, part of being a godparent is if we're not here, you're gonna have to walk our child through life and help them navigate through their faith and be an integral part of that." And so, with that in mind, if something were to happen to us, would you be interested? Would you be like, would you be up for the task of, being the guardian for them? And we've got four kids, and so asking them that question, they have three of their own. So that would be a fun environment for all parties involved, I think. So hopefully we never have to address that. But that would definitely be
Technically, people are making a commitment,
mhm. Yeah,
in some capacity. Hopefully, it never plays out, right?
right.
That's the whole point of estate planning. But I think besides like the financial aspects that we talked at the beginning, I think this is the other component that keeps people from doing estate planning.
Yeah.
Because it's all good and, and dandy to talk about it. But then, hey, I'm gonna meet with Chris. We talked about that I need to put together a guardianship or I need to assign somebody that in the event of me and my husband's death, what's gonna happen with our children so that they don't end up in the court system and going through all that. Now it's forcing you to have those difficult questions. And it could even be between you and your husband, right? Like maybe you and your husband have different opinions on what should happen. Oh, I want them to go with my mom, or I want them to go with my sister. And
And
then
I see
that
that all the
creates
time.
a
Yep.
whole thing, right?
Yep. I see that all the time. The thing I don't want to alarm anyone about is, I mean, it does happen where both mom and dad pass away. But if something, God forbid, even when you're young, if something happens to dad, mom is the natural guardian and she will have custody of the kids and vice versa. Something happens to mom, dad is the natural guardian. Dad will have full custody of the kids. The guardianship provisions are only in the event that both mom and dad pass. And I do recommend to my clients that they get on the same page with that. Because if mom says my sister and my cousin are going to be guardians, and dad says I want my dad and my brother to be guardians, then you got a conflict, and it's going to be litigated in court, and it's going to be a mess. So I recommend that, at least for the guardianship provision, you can figure out the finances. You can have a team approach to that. Not a big deal. I mean, it can make it messy, but it still will sort itself out because it's just numbers. When you're talking about the custody and care and control of your children, though, be on the same page with your spouse. And so that's where the hardest conversations come in.
Yeah.
Um,
I want
but yeah,
to,
life insurance,
that's what I
are,
was gonna say.
you
We
mentioned
could go
that. Yeah.
so deep into this. Like we could literally talk for an hour just over guardianship because I think
Yeah,
it's such a serious, it's a tough topic. But in that, life insurance is kind of like that last piece of protection, I think, in the guardianship is like, okay, if you will take over, and then in the event there's this policy in place to help provide for my children.
that's right. That's
Because
right. Yeah. And so the way we have ours structured is we have a life insurance policy that's payable to the trust, and then the trust has sub-trusts for each child. And so let's just use round figures. Let's say there's $1 million policy on me, 1 million on my wife. That's $2 million. 4 kids at 2 million. That's $500,000 each, plus the equity of the house. That's what they're working with if something were to happen tomorrow. Um, and so, that can be a very, $500,000 if you inherit from mom and dad when you're 7 or 1 or whatever. It can be something that, well, just quite frankly, it needs to be administered properly, because if that's blown, then you're not, and that's why I don't recommend you leave that directly to. I see people with life insurance sometimes name their 16-year-old as the beneficiary. Okay, fine.
Mhm.
Here's what happened if you die tomorrow. Um, Depending on what your will says, if you have that person as an outright beneficiary, it doesn't matter what your will says, because it's going to go to them, but it's going to be held at the court system until they're 18. As soon as they're 18 years old, they take that $500,000, and guess who just went and bought a Ferrari at age 18, or guess who went and did something stupid and knucklehead decisions, and so these are things that you might have life insurance right now, and you might want to revisit that conversation with your estate planning attorney, and your financial advisor, because if you've got your minors named as beneficiaries, it can cause a huge problem for them.
Wow.
It's not going to be administered pursuant to your will. If you name them as beneficiaries, it's going to basically be payable to them. And then it's going to be tied up in court, payable to their guardianship estate. And then once they're 18 and they're lawfully allowed to inherit that, they're going to get a check from the court system that wasn't really very interest bearing. And they'll
Does
be on
the
their way.
does the does the trust remove the need of guardianship?
Yeah, it can. So in my case, life insurance payable to the trust, I've got, let's just say, use my 7-year-old, for example. If I died tomorrow and my wife died tomorrow, her $500,000 would be administered by a trustee whom we've named, and that trustee would have the authority to invest that money. And so that trustee, even if, I would tell them to go talk to Chris Morrison, right? Chris Morrison, if he's getting, just kind of your standard market returns every year, year over year at an 8% return, that money is actually going to grow. And she might be in a spot where she never needs money again for the rest of her life. And so
Mhm.
that would be kind of the idea, with.
Because the guardianship seems like a nightmare. I mean, that's like 10 times worse than probate from
Yeah,
what
absolutely.
from what I've seen,
Oh
it's
yeah. Yeah. I've got
counseling.
one right now where we've got, minors who are each inheriting $20,000. Unfortunately, they're over that $15,000 threshold, and now we've got to do guardianships. And mom is living, dad is living. They inherited from a grandparent, and just the way they.
Right. They didn't know. They thought they were doing the right thing, and then, they didn't know. Let's pivot onto, we're talking about this sensitive topic about children and minors and planning for all that. When you have somebody with special needs,
Mhm.
you know,
Yeah.
You're talking about long-term care, you're talking about someone that's going to need a caretaker.
Yeah.
Um, you know, uh, how does that
One
play out?
one thing I do in every single estate plan, whether it's a will-centered estate plan that I'm forming for a client, a revocable trust, an asset protection trust, you name it, every estate plan that I prepare, I put special needs provisions in it. The supplemental needs trust is what I call it. Kind of, goes hand in hand with special needs, supplemental needs. It's a contingent trust. And the reason I put that into the documents is that I don't know what's going to happen to my clients and their families from the time they sign their estate plan to the time they pass away. I don't know if your kid's going to get in a car accident tomorrow. Actually, I had something like that happen a couple weeks ago. I had a client who came in for a signing appointment on a Friday, and they were supposed to come pick up their binder on the following week. Um, I believe they were coming on Wednesday to pick up their binder, and then they didn't show up. They actually called in and said, "Hey, we're going to try to make it there on Friday, but we just don't know if we can get there." And I said, "Okay, fine, whatever. Just let me know when you're picking up the binder." Well, they come in on Friday and they tell me that the reason they missed it on Wednesday was because their son was just involved in a motorcycle accident, and it was a pretty severe one. Um, Thankfully, he's okay. Thankfully, he's not going to, be supplemental needs, but they have peace of mind knowing that if something were to happen to him where he has to go on disability or Medicaid, that he doesn't have to spend down his inheritance to become eligible. Or to maintain his eligibility. So I build that into the estate plan. And I do build in things like care manager provisions and things like that, just to ensure the best quality of life is there for your beneficiaries.
What are the circumstances of the supplemental? Because I think everyone understands at large, special needs or
Same
someone
thing.
with,
Yeah. Yeah, it's the same thing. It's just a nicer way of saying it.
is there something in there? I know it's kind of off, kind of weird, but someone that maybe has like a drug addiction or something like that. Would that fall into anything like that?
It can. I think you'd need, if you're concerned about a child having, um, gambling or drug or alcohol addiction, something like that, you can build in provisions to the trust that would restrict their access to income and principal of it. That's really done on a case by case basis more so. If they have such a problem with addiction where that they're discharged to a facility, they're, it depends on how the document defines special needs, supplemental needs, right? So typically, a definition of supplemental needs that I use is where you have two licensed physicians stating that you cannot handle your finances or medical decision making, or you've been adjudicated incompetent by a court, Duval County, St. Johns County, you've gone through the incapacity proceedings. Or the third one is you're absent from the jurisdiction, I think, for about a period of 5 years. No one can find you. That's where you can be deemed incapacitated.
Mm,
And so, does an addiction fall within the framework of that definition? I think it certainly can. If there's two licensed physicians saying that you have such an addiction that you can't handle your inheritance.
for yourself.
Mhm.
Yeah.
Um, so, I guess the short answer is it depends, but you can make the document more restrictive. You can make, the provisions, the contingencies, the access more restrictive than
Yeah, people that have, the long-term care children or, children with special, different circumstances, right? Families, do have issues sometimes.
Mhm.
Instead of just kind of like pretending like it's not going to happen or pretending like it doesn't exist, you can actually plan, to be able to provide for that individual in the best way possible. Because if you don't put anything in paper, then forget about it. Um, when it comes to actually like special needs and long-term care, I heard this through the grapevine, so I'm gonna throw this out there to see if this is true or not true. But I heard that if you have a special needs trust, the entirety of your estate, right, of what the value of the trust is, Um, Once that special needs person passes away, then the rest of the monies from that trust is then given over to the facilities or the,
Not
okay,
always.
okay.
Because you're right, that there are circumstances where that can happen.
Mhm.
There are effectively two types of special needs trusts. There is a first party special needs trust, which is formed by the individual who is in need of Medicaid, right? They have assets that they're putting into their trust, so that they have availability to those resources and access during their lifetime. And with the first party special needs trust, yes, in the case of, whatever assets and resources are there, whenever they pass away, if those assets and resources um, are less than what the state would file claim for, then yes, those assets and resources must be surrendered to the state. Um, but there are other types of supplemental needs or special needs trust, particularly a third party special needs trust. Third party special needs trusts are formed by usually a parent, can also be formed by a grandparent. And those types of trusts actually have contingent distribution language for what happens to the remaining interest when the special needs individual passes away. And in most cases, it'll revert back to the parent or grandparent's heirs, or if the special needs individual has their own descendants and children, then it would pass to them. So it really depends on the structure of it. And that's why it's important also to talk to a lawyer about it, because depending on the circumstances, where it looks like you might need to form a first party special needs trust. Well, doing that can have huge ramifications on the assets after the fact. And if there's a way by and through a settlement agreement where we can ensure, and I've been involved with personal injury cases before, where sometimes those personal injury funds, they have to set up a first party supplemental needs trust. Well, the devil's in the details. And if we can get all sides to agree and the court to approve a third party special needs trust, then guess what? We've just protected the assets from the state. And so there's ways to do it that are to the benefit of the client, and that's really what our job is.
Is it subject to like judges and their opinions on how to oversee things like that?
It's
Can,
subject to the rules, as long as you properly notice all interested parties.
mhm.
If the state doesn't show up, you're
Not a
good.
problem. Moving on onward. This has been incredible, and I think diving into these intricacies of like, I think these are the reasons that prevent people from moving forward into estate planning. And you're making it very real, just very authentically real, and it makes perfect sense. Talk to us about the other documents that a person should use and should have as far as, a full estate plan would include power of attorneys.
Yeah.
Um,
Yeah, a durable financial power of attorney is critical to every single estate plan, as is a healthcare power of attorney, also known as a healthcare surrogate. When I draft estate plans, I do it in a way where I prepare a standalone financial power of attorney, so a durable financial power of attorney, a healthcare power of attorney. I do a standalone HIPAA authorization, and I could go on and on about why I do that separately rather than included in the document. But the cusp of it is I do termination. I put termination language in it for 2 years after date of death, and part of the reason I do that is so that if the individual is ever involved in a wrongful death action, the named parties on the HIPAA authorization can actually access those medical records for a period of 2 years and go take it to a personal injury attorney. Um, and then I prepare a living will, also known as an advance directive. So those four documents are critical to every estate plan. Um, Part of why you would need the financial powers of attorney, um, you know, your spouse, even though your spouse is your spouse, if your spouse is not named on an account with you, if it's just Chris's account, Macy can't access it, right? Now we have things for the most part jointly titled or titled in trust where that's not an issue, but I want to make sure she has the ability to access things, the ability to file my taxes, the ability to do things that I cannot do. You know, if I have business interests, she can manage the business interests. Those are very, very
At
important
full
things.
capacity, I mean, with a financial power of
No, no,
attorney.
no. So in the event of my incapacity, right? So as a safety net. Now, again, she could, in theory, use the financial power of attorney while I have capacity. But that would
I,
be kind of at the discretion of the bank or advisor that she's communicating with. You know, if I'm out of the country and she needs to, sign a document for my life insurance guy, she can do it. And so, in a healthcare power of attorney too, your spouse can make decisions for you just as a matter of course in Florida. But if your spouse is not available, who is the backup? They're not going to talk to anybody. They're probably not even going to talk with your children unless you have a power of attorney in place. So those documents are all really essential for estate planning purposes. I'll give you another, for example, real life example. You've got an 18-year-old who's about to go to college. Guess what you can't do? You can't make medical decisions for that person. You can't make financial decisions for that person. That child that you have raised from 0 to 18 is now an adult. It is very, very important that you get a financial power of attorney, healthcare power of attorney, at a minimum, and a HIPAA authorization for your kid. So if something happens at college, if they're in a car accident on the way back, if they need to talk to financial aid, you want to be able to talk to their advisors, their doctors, etc. Once they turn 18, they're not your kid anymore, from a standpoint of you having authority to make those decisions.
mhm.
And that can be very frustrating for
Oh, that would be
parents.
devastating. Yeah, it would be. I
So,
think a lot of people are not even privy to that information. They don't even think that through what would happen in the event, you
right.
just assume that, of course, the doctor would talk to the mother of an adult child. Why wouldn't they? But it doesn't work that way.
Right.
With the financial power of attorney, I mean, can effectively, if someone were to pass away or I guess it also can be during when they're aging, right? When they're getting older and they're kind of not keeping up with things as good as they used to, all right? You have that financial power of attorney. Um, is that as good as gold? I mean, can you take that and do whatever you need to do with it? Or are there limitations to what type of business or type of what is included and what is not included, I guess.
It depends on how it's drafted. Um, it depends on the verbiage of it. There are different types of powers of attorney that you can form. You're probably familiar with specific limited powers of attorney in real estate, where one spouse is giving someone else the authority to sign on their behalf. Um, it doesn't, what matters is what's in writing. And so with the way that I prepare my powers of attorney, there's a number of you know, overlapping things that touch on everything you just described: business powers, tax powers, whatever, handle personal finances, etc. I do put in, I want to say it's about 10 specific special powers that clients have to initial to give their agent, their power of attorney, the authority to act on their behalf. So we're talking about things like changing beneficiaries to retirement accounts, talking to their advisor about retirement accounts, changing the distribution schedule of annuities, doing long-term care and planning, having the ability to alter or amend their trust and their estate plan, having the ability to change beneficiary designations. Those are all very, very powerful things,
Mhm.
that I take a degree of time with my clients at the signing appointment going through them so that they understand what the ramifications would be. I don't have as much of a concern when it's a spouse granting authority to a spouse, rather when it's dad or mom granting that authority to a child, an adult child even, can take that authority and misuse it.
Mhm.
And so I'm very it's a case by case basis with it. That power of attorney is going to expire at your death. So, it's a powerful document during your lifetime, but when you're gone, that power of attorney expires. It's no
Okay.
longer valid.
Okay. Okay, that's a
Um,
good point. But you see people putting those in place primarily once they're aging, you think? Or, getting those, or I mean, you recommend even if like an 18-year-old, oh, but you say after death it would be irrelevant. Um, but what would be somebody's need for to have that power of attorney? I understand when someone's aging and not able to kind of keep up with things, but when you're alive and well and young, and what is the benefit of having that financial power of attorney, not husband and wife, but just outside of that
mhm.
relationship?
Um, so again, the durability language of the power of attorney means that it survives your incapacity. And so if you have these powers of attorney in place and they're durable, they're still valid once you're incapacitated. And if you have done this basic level of planning where you have a durable financial power of attorney and a durable healthcare power of attorney, if those documents are in place where you've appointed someone to manage your money and make medical decisions for you, you don't need to go through a guardianship proceeding if you're incompetent. If you get in an accident, if you can't handle your financial affairs, you can't make medical decisions for yourself because of how bad the accident is. If you've got these documents in place, then you don't need to go through the court system in most cases. And
Mhm.
so that's where having these powers of attorney are very powerful. And quite frankly, these documents, financial power of attorney, healthcare power of attorney, living will, HIPAA authorization, those four basic documents are documents where I can represent clients from age 18 to age, you name it,
Mhm.
150, however old they are. Um, those are four key estate planning documents where I can represent someone for life and help them, make sure that they've got someone appointed for them because those documents are only valid, except the HIPAA authorization, the way I draft them, those documents are only valid during lifetime.
Mhm. Could they be drafted to serve after post death?
No, powers of attorney expire at death.
Okay, I took a shot.
Under statute. The folks who would have the authority after you pass away are your executor under your will or your trustee under your trust.
Got it. Chris, literally, I feel like I just went to a state law school right now,
Come
okay?
on. Yeah.
I mean, you really conclusively broke down really what are the basic needs from beginning to end. Wills versus trust, and then, having these durable power of attorneys, and then what are the critical things that we have to think through, our children, and special needs. Thank you so much. You made it so simple and easy to understand. So if anybody on the call has a question that they would like to ask Chris, I would love for that opportunity. I know a lot was said. And so if you want to come off the screen, or if you want to drop a question in the chat, we would love to, facilitate that for you. We do have in the chat our link for our upcoming event, so you'll see that there. Let's see here. Chris Leddy, you're amazing. Oh, Chris Morrison decided to join us. Thank you, Chris. You got here just in time. We save the best for last. So thank you, Chris, also for sharing your information, so people can reach out to you directly. What we did today is the deep dive that we're looking to curate in our group. When we get together on March 6th, we are going to have these conversations that we're having. We are going to be breaking it down into a digestible handout for our group, so that they can have, our goal is to get the basics of all of this pre-planning, aging in senior care, and then after the post-death. So I'm really excited to kind of crunch all this together. And I think that we're really uncovering a lot of things. I know I'm becoming more valuable every meeting that I attend, sitting with a professional like yourself. So thank you a million bazillion. We'll go ahead and I did want to just end us off with a couple of quick reminders. We do have our lunch sponsors, and many of you have already signed up to be one. We want to give some shout out for Peter Gilman with Estate Trust and Tax Preparation. He was our lunch sponsor for February, and he is your man. We are going to have him on the panel to break down estate and trust taxes because those are big ones. These weekly meetings are happening every Tuesday at 12 p.m. So please feel free to jump on live. We are going to be putting together a place where these videos will live. That is being put together right now. But as of right now, you got to be there, get in there, or you miss it. Okay. So these are happening live. They're not going to be sent out, the recordings. So if you're interested in joining on this panel and giving your expertise, reach out to myself or Holly. If you provide these services, we want to interview you. We want to present you to the group. And with that being said, it's a wrap. Thank you, Chris. Thank you
Thank you,
guys for
guys.
everyone that's attended. Woo, number 2 down the belt, and we're on our way. So next week is funeral planning. So it should be interesting. How much do you know about funeral planning, Chris?
Yep, not a lot. Um, I just refer people to different funeral homes to get that done, or sometimes they've got it done when they come to me, so it's not
Same
really.
here.
Yeah.
Yeah. So it'll be a very neat conversation to really hear their side of things and how they help people pre-plan, and they talk about it so casually, the same way that you talk about, your experience. And I think that's what kind of is just like we said, removing the veil. Instead of just sending your clients off, oh, you got to the funeral home. Now you're actually going to know what is the conversation like when you're sitting with a funeral planner, and so it's really neat. So thank you guys for being here live, and we will see you on the next one.